What's up, everybody? So I'm back with another video going over some old news articles from Stephen Avery and Brendan Dassey's case. We're still back in September of 2003. Now, my original plan was to read every newspaper article there was, and there's a bunch of them, but a lot of them just say the same things over and over again. There were multiple publications, there were multiple newspapers, multiple stories, but they were all just pretty much the same story over and over again. So instead of just reading the same story every time, I'm just going to go back and look for new information from all of the papers, and then I will go over those articles. Like I said, instead of reading the same thing over and over again. Now this one is from September 22nd, 2003 from the Madison Capital Times. It states that freed prisoner gets an apology. Now this prints the letter from the lady who Stephen Avery was convicted of attacking in 1985, but then it was later discovered that he didn't do it due to DNA testing. This article states, the victim of a 1985 sexual assault that resulted in the wrong man spending 18 years in prison has apologized in a letter to him. Stephen Avery of Two Rivers was released from prison September 11th, 2003 after DNA testing pursued by a law school group proved to his sentencing judge that he didn't commit the crime. The tests instead indicated a man serving prison time in another assault committed the attack. The woman who was sexually assaulted in 1985 after jogging on a Lake Michigan beach testified at Stephen Avery's trial in Manitowoc County Circuit Court that he was the man who attacked her. Jurors have said her testimony was a convincing factor in their decision to convict, despite alibi witnesses who testified that Avery wasn't at the scene of the crime. The letter of apology mailed Friday was reported in Sunday's Milwaukee Journal. The victim's lawyer, former Wisconsin Supreme Court Justice, released a copy of the letter. Avery, contacted Sunday by the Associated Press, said he had received the letter. "I guess it's a start," he said. The Journal also reported Sunday that its review of more than 1,000 pages of court documents and law enforcement reports suggest that authorities made Avery a suspect so quickly that the case became a virtual steamroller. Geez, it seems like they've done that twice to him now, doesn't it? On Friday, responding to a request, Manitowoc County District Attorney said her office would conduct a review of the investigation and prosecution of Avery. State lawmakers plan to hold hearings as well. Among issues lawmakers plan to review its compensation limits for those wrongfully convicted. State law provides compensation up to $5,000 for each year imprisoned with a cap of $25,000. It's insane. Avery told the Associated Press Sunday that he felt fair compensation for him would be about $1 million a year for the time he spent behind bars. I mean, even that's not enough. Like 18, you're never getting that 18 years back. $1 million a year is a lot of money, sure, but you will never get that time back. And now, he was never getting it back twice. He has said the conviction cost him his marriage, which ended in divorce after he was sent to prison, and his relationship with his children, besides the hardship of incarceration. He said a relative in law enforcement at the time told him that when a picture was prepared of a possible suspect in the case, his picture was used rather than making it from a description provided by the victim. You can actually see them talk about that, I think, in the first episode of Making a Murderer during the first season. The cops already knew they set me up. The assault victim told the Journal that the photo of Avery and the other prisoner show they looked so much alike they could have been brothers, but the authorities at the time showed her only a photo of Avery, even though the other man had been caught 2 years earlier for exposing himself and trying to grab a woman in the same area. Her letter to Avery begins, "There are no words sufficient to express how deeply sorry I am for what happened. Your wrongful conviction has taken away 18 years of your freedom, something that can never be given back to you. I wish it was in my power to restore those years, but it's not. The only thing I can offer now is a sincere apology that I identified you as my assailant when you were not." You know, it's not even her fault. She was showed a picture of Stephen Avery and was told that's the guy. So of course she's going to pick him out of a lineup and say that that's the guy because she was told by police that's the guy. You're supposed to be able to trust police, and she trusted police. But the police in this situation were just too busy framing somebody instead of going out and getting the right guy. The woman also wrote that she would like to meet Avery someday. There's another thing printed up here. The text of the letter by the victim's lawyer, former Wisconsin Supreme Court Justice, as mailed Friday to Stephen Avery, who spent 18 years in prison for the crime he didn't commit. There are no sufficient words to express how deeply sorry I am for what happened. Your wrongful conviction has taken away 18 years of your freedom, something that can never be given back to you. I wish it was in my power to restore those years, but it's not. The only thing I can offer now is a sincere apology that I identified you as my assailant when you were not. I am also aware that after 18 years of imprisonment, those words must sound inadequate in the face of your tremendous losses. Following my attack, I realized I only had two choices. I could allow the assailant to destroy me, or I could choose to move on and become strong and try to make something good come from a terrible event. I tried to do the latter, though it had been a long journey filled with both progress and setbacks. I experienced many emotions, from overwhelming gratitude that I had survived to anger and despair over what happened to me and my family. You are also a victim facing the same choice and a similar journey. While you are overjoyed by your freedom and being reunited with your family and friends, it is likely that you may experience great sadness and anger about your lost years. My hope for you is that your loved ones and the community will give you the support you need as you begin your new life. Since July 29th, 1985, I have prayed someday that I could sit across the table from you and talk, as I had many questions about what happened on that day. Perhaps that prayer will be answered, and I suspect it is you who will have questions of me. If at some future time, when it is appropriate, you would like to meet face-to-face with a facilitator and talk, I am willing to do so. You may contact me through your attorney or mine. My other prayer was that justice would be done in the case. My prayer was answered on September 11th, 2003, when you were reunited with your family. Ultimately, no one can give you back the time you lost. My hope is that in the years ahead, many good things will happen for you and your loved ones, and that something positive will come from this incredible tragedy. When I testified in court, I honestly believed that you were my assailant. I was wrong. I cannot ask, nor do I deserve your forgiveness. I can only say to you in the deepest humility how profoundly sorry I am. You may be richly blessed, and may each day be a celebration of a new, better life. It's actually a really nice letter, and I don't blame her. I mean, she was told who did it, just like Brendan Dassey. She was told who did it and then pointed it out. Brendan Dassey was told all the information and then said it back to the prosecutors, and that's why he sits in prison to this day. The only difference is this lady didn't get convicted of a crime. Now, this next article is from the Madison, Wisconsin State Journal from September 24th, 2003. It states, Fed should expand use of DNA evidence. The exoneration of Stephen Avery, who served 18 years in prison for a crime he did not commit, highlights the benefits of a 2001 Wisconsin law on DNA evidence and underscores the need for a similar federal statute. Avery, who had been wrongly convicted of sexual assaulting and trying to kill a jogger in 1985, was championed by the Wisconsin Innocent Project at UW-Madison Law School. He was the first prisoner released based on DNA evidence since the state law passed, and the third in state history. Nationally, 137 prisoners have been exonerated on the basis of DNA evidence, including several who were awaiting execution. Man. Co-director of the Wisconsin Innocent Project said he hopes Avery's plight will provide for a criminal justice study commission to more broadly examine flaws in the justice system and reform them. Wisconsin law would provide a good model for the reform, what it does, and what federal law should do, in demand of preservation of all biological evidence collected in crimes, and allow convicts who claim they're innocent to access DNA tests. I fully think that should be a thing. Because if they're guilty, it's just going to show that they're guilty. But if they're innocent, it's going to show that. A measure sponsored by a U.S. senator would also improve the quality of legal defense available in death penalty cases. Fortunately, a provision is not needed in Wisconsin because it rejects the death penalty. Nevertheless, Avery lost 18 years of his life, and the State Justice Department new Public Integrity Unit will cut its teeth with a review of what went wrong in the investigation and prosecution of Steven Avery. He was 25 when he was arrested, a husband and father of 5 children, including newborn twin sons. He is now 43, his wife divorced him, and his children are grown. State law limiting compensation to $25,000 hardly seems much to cover those losses. Much of the coming re-examination of this case will no doubt focus on the fact that most of the victims of negligence or worse can sue for lost wages, pain, suffering, and other compensation. But frankly, no amount of money can right the wrongs inflicted on Avery. Instead of arguing over cash, we must more efficiently apply science to criminal justice to keep the innocent out of prison and free those who have been doing time for someone else's crime. Regardless of whatever the state offers him, Avery must count himself lucky he got out without access to scientific proof. How many others won't? That article is bang on. They should have access to DNA testing, because if someone is claiming they're innocent, they're not. Everybody just claims they're in prison, they're innocent. Everybody in prison claims they're innocent, most people anyway. And if they're actually guilty, it's going to show that. But if they are innocent, it's going to show that too. So no harm, no foul. They should absolutely have access to that DNA testing. This next one is from the Madison, Wisconsin State Journal, September 26, 2003. Inmate in Avery case transferred. He was moved from prison where victim was a volunteer. Green Bay. A man linked to a 1985 sexual assault by DNA evidence that exonerated another man has been transferred to a different prison because of concerns for his safety, a State Department correctional spokesman says. The man was serving a prison sentence at Green Bay Correctional Institution for a different sexual assault case that occurred in 1995. He was recently transferred, DOC spokesperson confirmed Thursday. The man was implicated in the 1985 assault of a woman jogger near Two Rivers through DNA testing, which proved Steven Avery was wrongfully convicted of the crime. Avery was released earlier this month and after serving 18 years in prison. The DOC said the victim of the 1985 crime was a volunteer at the Green Bay Prison Program, which inmates discuss the impact of their crimes on their victims and the community. She is well known by inmates and well liked. For his own safety, we moved him. Green Bay warden said correctional officers were worried that if prisoners found out who was now linked to her attack, they might hurt him. The issue of what they might do to the person who hurt the person that helped them was a big issue for us. It's amazing to watch some of these people who are in for some pretty vicious crimes. They start to break down and cry and empathize. The other woman the man was convicted of sexually assaulting in 1995 said her life would be very different if her attacker was arrested in 1985. They let this guy out to commit. They didn't arrest this guy back in 1985, allowing him to commit more crimes. You have 85, my sexual assault, in 95. She said he had 10 years of terror. Had they caught him back then, a lot of things would be different. 100%. They let the criminal go to commit more assaults. Well, that's the 3 stories from these papers. Let me know what you think. Leave some comments below. I hope you're having a good day, and I'll see you again soon.